Joining us now, NBC senior legal correspondent Laura Jarrett, Andrew Weissman, former lead prosecutor to special counsel Robert Mueller, and former U.S. Attorney Joyce Vance. So, Laura, take us through your latest exclusive reporting and the legal questions facing Jack Smith's team right now.
So what we know is that the grand jury is expected to meet once again after a pretty long lull. There had been so much frenetic activity at the courthouse, so many witnesses coming out, in and out, and then all of a sudden everything stopped and they went dark. And the question was why. That was around early May. And we've now learned, multiple sources familiar with this investigation have confirmed to us that they are expected to meet again this week. Now, we are being careful here. Things can change. Reporting on grand jury activity is always fraught because the process is secret. And it's supposed to be that way. But that's what we are able to report, at least at this moment.
And Andrew Weissman, can you draw on your experience, give us a sense of what's going on behind the scenes? What does Jack Smith have to do before making a recommendation or presenting a decision to the grand jury? Is there a charging statement or a decision not to charge? You know, what have they been working on, do you think?
Sure. Well, I think the first thing for people to know is that it's very typical in a case like this, and frankly, it should be typical in almost any case, that the defense is given an opportunity to be heard. And that would be at two levels. The defense would be able to speak with Jack Smith and his team about any legal, factual reasons why a case should not be brought. And because ultimately, no matter, even though there's a special counsel, it is the Attorney General who has the ultimate authority to say yay or nay, that they could potentially appeal that. And I would think that here, that Attorney General Garland would hear an appeal. It wouldn't be atypical at all for him to do so under the special counsel rules. So that's what we could be seeing, that the reason we're seeing people coming in and out of the Department of Justice is for those kinds of things. And then finally, to your point about what to expect, is that assuming those appeals don't go in Donald Trump's favor, then Jack Smith would make a final presentation to the grand jury, present the proposed charges, may do a bit of a summation, reminding them of the evidence, and ask them to vote on any particular charges. Here, by all accounts, that is something that will happen in Washington, D.C., because people expect that that's where the charges will be brought.
And Joyce Vance, once that happens, these are sealed indictments, if they are going to hand up an indictment. When would we know? When would this become public? Would there be an arraignment? And would he most likely, the former president, show up if there were an arraignment after an indictment?
Right. The case will proceed like any other case. After an indictment is returned, if it is, the grand jury foreperson will appear in front of the judge who has organized this grand jury to make a return of service, and then the indictment will be taken to the clerk's office, where it will be added to the docket, and this case will, in essence, be initiated. That will be followed at some point by arraignment. It could be a matter of days or even a little bit longer, but then this case will be in play. There will be a discovery process. There will be pretrial motions. Some of that will be public, but much more of it will go on in private.
Andrew, let's talk about the timing if there were such an indictment, because there's a critical issue, which is the precedent, at least within the Justice Department, of not doing anything within 6 months of an election. You've got the first caucuses coming in January and February. Yep. So is there a time pressure here?
Yes, I think that the prosecutors and potentially the judge who is assigned may feel that they have a tension here. They want to be fair to the defendant. Here it would be, if there's a charge, the former president, meaning that he's entitled to due process, to discovery, to time to make motions. By the same token, the American public, as well as the defendant, are entitled to a decision, meaning that if he is somebody who's running for office, if the voters are thinking that they may want to vote for him, then it is important to have this go to trial even before any nomination would be decided, so that everybody has the information about whether a jury has found proof beyond a reasonable doubt as to any particular charge. And frankly, that's in the interest of the American public as well as the defendant, that he have his day in court.
And Laura, of course, Jack Smith is also the special counsel who is investigating January 6th regarding Mr. Trump and his involvement and others.
Yeah.
Do we think that if there were a decision to indict, that it would just be on the classified documents, which is the case that seems to be coming
As far as we know, that the situation on the documents is relatively straightforward. The situation as it relates to January 6th, I think, is fairly complicated, and it doesn't mean that it won't eventually reach a decision. But I think that it's not in the same place as the classified documents issue. So I think you should think about them on two separate tracks.
And Joyce, finally. We know that Mr. Trump is, as recently as today and yesterday, calling it a hoax, saying that he'd done nothing wrong, and every defendant, presumably would have the right to try to plea bargain if he's indicted before going through all of this. Is there any notion that they would have some negotiating room here with the former president to try to avoid all of this?
It's tough to imagine Trump doing what he would have to do to plead guilty. He would have to stand up in open court under oath and say that he was pleading guilty because he was, in fact, guilty. But if this was any person other than Trump, the smart move here would be for his lawyers to go to DOJ and to argue that DOJ's own precedent involving cases involving two former CIA directors who retained classified or sensitive material says that there should be a misdemeanor plea here. It's tough to imagine Trump doing that.
Laura Jarrett, a big week for all of our legal eagles here. Andrew Weissmann, Joyce Vance, thanks for starting us off on Monday.